Court all rise.
So the next question that I posed was, does the legal structure to be adopted to fund and run the development make a contribution that would otherwise be immaterial material? And I'm going to tend to go into the detail later. But in this case, and I'm turning to paragraph 27 in the first appellant's case, which is on page 85 in core volume 1. So the first appellant accepts that the causes to which the money could be devoted from the community fund are not all themselves directed to matters of land use. And so there's an acknowledgement that some of those matters do not relate to land use. But what the first appellant argues is that because of the nature of the legal structure or vehicle used to carry out the development imposed as a result of Condition 28, in effect, something which would otherwise be immaterial becomes material. And the same reasoning caused the first appellant to accept in the Court of Appeal that if the community benefit fund had been offered by a commercial wind farm developer, it would not have been material and it would have been unlawful for the planning authority to take it into account. So that's paragraph 36 of the Court of Appeal's judgment, and that's at page 224 in the first core volume. But as held by the Court of Appeal, and we rely particularly on paragraphs 39 and 63, no sensible distinction can be drawn between this scheme and a scheme which is wholly commercial. And the reason I make that submission is because we do have details of how it is envisaged this scheme would be run. It was said that it would be similar to the Alvington Court scheme, which had a similar structure. And can I ask the Court, please, to turn to page 393. And Mr. Kingston is very keen to emphasise that a community benefit society has to be operated for the benefit of the community, and that that is policed in effect by the Financial Conduct Authority. But, and there's no dispute about that, but it's important to look at the actual structure of what is here proposed, which is proposed on the basis of Alvington. And the Alvington structure, one can see, is that once planning permission had been obtained, and that's obtained by the resilient special purpose vehicle for that scheme, that was and page 241, paragraph 22(1, that was Resilient Energy Alvington Court Limited. one then goes to paragraph 24 and 24.2. The Community Benefit Society purchased the planning and development rights from the company, which is owned by the landowner and the Resilience Centre Limited, for approximately £580,000, made up of £80,000 in cash, £100,000 withdrawable shares, and £400,000 non-withdrawable shares. So once the special purpose vehicle, which is the Resilience Centre and the landowner, has got its planning permission, it sells the planning and development rights to the Community Benefit Society. Then the Community Benefit Society has to pay a rent to the landowner. That's referred to at 25.2. That's 7% of gross turnover, and that's shown in one of the colour illustrations you were handed this morning. And then one goes over the page to 394. There are management fees which are paid to the Resilience Centre, which is 7.5% of the turnover. And in addition, the Resilience Centre takes another fee of 1.9% of the funds raised, plus value-added tax, to administer the community benefit value. So, yes, the scheme is eventually run by a community benefit society, but it's not an entirely non-commercial venture, because those, and no criticism of this, but those who promote the scheme get the planning permission, then sell that right on to the community benefit society. So given that is the structure, there is, in our submission, no distinction to be drawn between a scheme promoted subject to a condition such as condition 28 and a wholly commercial scheme. And the Court of Appeal saw no distinction between the two. But in any event, even if you weren't persuaded by that argument, the appellant itself recognised in their summary grounds of defence in the planning court that there's a clear distinction between, on the one hand, the scheme being run by a community benefit society and the community donation. And it's the community donation which is the element which the respondent argued before the lower courts was the consideration that was not material. And if I can take the court, please, to core volume 2 and to page 487, I hope. We have here, this is starting at page 483, these are the then interested parties' summary grounds of opposition in the planning court. And page 487, paragraph 12 and 13, the interested party confirmed the project would be brought forward by a community benefit society, and then separately to this, £500,000 would be donated to the local community over a period of 20 years. And then paragraph 13, it's important to be aware that throughout the application process, there was a clear distinction made between the establishment of a community investment scheme and the annual community donation. So if that is right, the donation, the 4% of turnover, can be separated from the fact that this is a community benefit society. And even if the appellant's argument is right, that by promoting this scheme through a community benefit society, it promotes an element of government policy and therefore is material, it doesn't actually cause them to succeed in the argument, because the donation, the community donation, is described by them as separate, and that is the part which is not material. So, in answer to the question, does the legal structure make a contribution that would otherwise be immaterial material? No, if one looks at the structure, and in any event, the complaint is about the donation, not the structure, and the donation does not flow from the structure. And those two points, the one I made before the break and the one afterwards, in our submission, answer the case. But having said that, and now, if I may, will turn to a heading of what is a material consideration, because that is, the court may think, the issue to be grappled with. If I may, I'd like to start with going to Authorities Bundle 1. Check that I've got the right reference. It should be 1258. So it's tab 4, page 1258. And I go to the statute where the words are found. So, section 70, subsection 2, and this is, as Mr. Kingston submitted, a reenactment of earlier provision which has been in force since 1947, at least. So, one finds the words 70, subsection 2, paragraph A, reference to the development plan, and then at C, any other material considerations. And I pause there to just draw the court's attention to the other paragraphs that appear in section 70, subsection 2, because the appellant's argument is that through policy, a new form of material consideration can be introduced. Our argument is no, what is a material consideration remains, but through policy you can change the matters which fall within land use planning. If the government, Parliament, wishes to introduce an other consideration, it has the ability to do so, and it's done so. And there are two examples there at paragraph AA and B. Now, if any considerations relating to the use of the Welsh language, so far as material to the application, had been, if you could just make something material by making a government policy saying those considerations are material, it would have been unnecessary to introduce that provision. So it's any local finance considerations, which, just for reference, are defined in subsection 4, and you find it on page 1261. But if the appellant was right, and you could just make something material by changing government policy, there would have been no need to add AA or even B. So that's the statutory provision. The other important statutory provision, which I don't ask the court to turn to, but Mr. Kingston's referred to, is section 38, subsection 6 of the Planning and Compulsory Purchase Act 2004, which is the provision which gives priority to the development plan, and we have that at page 1254. And a development plan's role is to set out policy which can then be applied when determining planning applications. National policy would fall into the category of another material consideration. So one asks, what does material mean? In Tesco and the Secretary of State, so this is the 1995 Tesco, and it's Authorities Bundle 1, tab 20, and I don't ask the court to turn it up, page 1680. Lord Keith indicated his agreement with Sir Thomas Bingham, as he then was, that material in subsection 2 means relevant. So, and that's at page 764G, which we have at 1680. So one then asks, carrying on through the process, relevant to what? Not put very elegantly by me, but that's the question. And in our submission, one has to ask, well, what is the purpose of all this, the decision-making process in section 70? The purpose is to indicate how planning applications are to be determined. So one then has to ask, well, when do you need to make a planning application? And that is governed by sections 57 and 55 of the 1990 Act, which are in the respondent's very slim additional bundle, which I hope the court has. So, and if I can go to page 2313 first, section 57. Subsection 1, subject to the following provisions of this section, planning permission is required for the carrying out of any development of land. So this whole complex structure of the Planning Acts really comes down, when is it engaged with actually making a decision about something? It's engaged when you apply for planning permission. And you only need to do that if you intend to carry out development. So one turns to section 55, subsection 1, page 2309 in this additional bundle. So subject to the following provisions of this section in this Act, except where the context otherwise requires, development means the carrying out of building, engineering, mining or other operations in, on, over or under land, or the making of any material change in the use of any buildings or other land. So that is at the heart of the system. And so in our submission, the answer to the question relevant to what is relevant to an application for planning permission for development. And then one turns to what is development? Answer, section 55(1). And it's in that context, in our submission, that Lord Parker's statement in East Barnet must be understood. So, slightly long way to get there, but that's how one gets to the classic statement by Lord Parker, and which of course was then endorsed by Lord Scarman in Great Portland Estates. So if I can just take the court to East Barnet, it's in the authorities bundle, tab 6, page 1291. And page 1297, 490 of the report, no paragraph numbers, but there is Lord Parker considering the term development, and then towards the bottom, and this was a case involving an enforcement action for a change of use, a potential enforcement action for a change of use. And the word material, this is towards the bottom of the page, comes in for the first time in the definition in the Act of 1947. But that must be referring to material as material for planning purposes. And although the word does not appear in the section 53 of the Act of 1932, it is clear and conceded that in considering what is a different purpose in that connection, planning considerations must be regarded. So Lord Parker was answering the same question that is before this court of what is material. And therefore, when one gets to page 491, 1298 in the electronic and in the bundles, and the first full paragraph, it seems clear to me that under both acts, what is really to be considered is the character of the use of the land, not the particular purpose of a particular occupier. So that is where the words taken up later by Lord Scarman come from. But and it's our submission to the court that there is the fact of the appellant's argument is that the court should depart from that approach. And that is an approach which has stood the test of time. Not only has it stood the test of time, but it's based upon an analysis answering the question, if material means relevant, relevant to what? It's relevant when determining applications for development. So that applies just as much today as it did then. And I've already addressed the court on Westminster and Great Portland Estates, but I rely on that. That's for the court's note. Authorities Bundle 1, tab 22, 1752, and paragraph 670C. That's the test of what is material based on East Barnet. And if I may, I'd now like to take the court to the Plymouth case, which is at tab 14 in the authorities bundle. And that is page 1515. And if I can take the court to page 1525. And this was Lord Justice Hoffman in Plymouth, 1525. The 3 Newbury tests are cited. And then Lord Justice Hoffman states, 1 and 2 are tests of materiality. In this context, considerations are material if they are planning considerations and fairly and reasonably relate to the development. So, and then if I can take the court on to page 1527. And to the penultimate paragraph, the last full paragraph, which comes under the quotation of paragraph B7 in Circular 16 of 91. And halfway down that paragraph, there's a sentence that begins, materiality is an entirely different matter. So materiality is an entirely different matter because there is a public interest in not allowing planning permissions to be sold in exchange for benefits which are not planning considerations or do not relate to the proposed development. And then there's a reference to the statements by Lord Justice Lloyd in Bradford and Lord Justice Staunton in Monaghan. Monaghan was the Covent Garden case. So, and I draw attention to that passage because it demonstrates how important materiality is in guarding the planning system against inducements being offered, even if to pay for wholly desirable matters, in order to seek to secure planning permission. And if one could just change what was material by changing a policy, the public interest would not be protected in the way that Lord Justice Hoffman suggests it is by applying the test of materiality. The threefold Newbery test, and I agree with learned friend Mr. Kingston that it's criteria 1 and 2 that we're concerned with here, not 3, was reaffirmed by this court in Aberdeen, which is at tab 5 in the authorities bundle. And I'd like to go first to page 1285, paragraph 44. And there, the court is emphasising the importance of the 2 Newbery tests on materiality a planning obligation which required a precondition for commencing development that if a developer pay a financial contribution for a purpose which did not relate to the burdened land could be said to restrict the development of the site, but it would also be unlawful. Were such a restriction lawful, a planning authority could use a planning obligation in the context of an application for planning permission to extract from a developer benefits for the community which are wholly unconnected with the proposed development, thereby undermining the obligation on the planning authority to determine the application on its merits. And in the same way, it could be offered. Now, in this case, we're not concerned with the planning obligation, but the principles are applicable. And if I can take the court on to paragraph 51, which Mr. Kingston referred to in his submissions, that's on page 1287. Mr. Kingston noted that in the respondent's case, reliance is placed on paragraph 51, first sentence, and he emphasises that the whole paragraph needs to be considered. And yes, of course, the whole paragraph needs to be considered, but the principle to be extracted is just by including a policy in a development plan that a particular matter is material, or in that case, the planning authority will seek such a planning obligation. The planning authority cannot make relevant what would otherwise be irrelevant. And that is because the guardian against, and I use the emotive term, buying and selling a planning permission, is materiality, and one goes back to Lord Justice Hoffman in Plymouth. Mr. Kingston submits and relies upon a series of cases to argue that the nature of material considerations have evolved over time to reflect changing economic and social circumstances. And yes, they have, and I gave two examples just before the break of changing considerations in relation to wind turbine, wind energy, and retail, in-centre, out-of-centre. Mr. Kingston relies on a series of cases, but amongst them are Mitchell, which is at tab 11 of the authorities bundle, page 1443. And that was a case about lower cost housing. He gives this as an example of how circumstances change. But in that case, page 1445, and the paragraph that begins just under the page number 62, it is common ground between the parties, as I understand it, that material considerations are those which serve a planning purpose, and that a planning purpose is one which relates to the character of the use of land. And then there's a reference to Lord Scarman in Great Portland. So there's no departure from that approach. What was determined here is that the need for a particular form of housing, as distinct from some other form of housing, did relate to land use. And that, 1446, third paragraph. And the fourth paragraph. Amongst the other cases that are relied upon by the appellant are the Copeland case, which, just for reference, I don't ask the court to turn it up, is at page 1547, tab 16, and that was a issue about proximity of fast food takeaways to schools. And if the court does have it, it's page 1553, paragraph 25. But in that case, it was accepted that proximity of a fast food takeaway to a school related to the use of land. So it wasn't by some policy introducing some different test of materiality or making something material which wouldn't otherwise be material. And it might be thought that's obviously so. It's to do with where you cite different uses. It's a classic matter relating to the character of the use of land. So our submission to the court is, it's clear that social and economic circumstances and therefore considerations do change, but the cases demonstrate that what I will describe as the touchstone for determining a material consideration has not. It's the same question identified in East Barnet and endorsed by Lord Scarman in Great Portland. The reason that the touchstone hasn't changed is because the nature of planning control hasn't changed. Planning permission is required for development, and what is material must be judged in relation to planning applications for development. So the answer to the question, what is a material consideration, is to go back to Westminster City Council and Great Portland Estates, where the reference is a planning purpose is one which relates to the character of the use of the land. And there is no need or requirement to change that test. If the court felt that it needed to bring a modern interpretation to that, I do not seek to put forward some better solution, because my argument is that that is the appropriate approach. But if the court were to use different words, they would, in my submission, have to relate to development as defined in section 55, because that is what planning permission is applied for. That is what planning policy gives guidance on. If I can now turn to, from what is a material consideration, to briefly turn to the community benefit fund, and I just, if I can, would like to draw the court's attention, and little more than that, to the range of activities on which this community benefit fund can be spent. For that, I need to go to Core Volume 2 and page 529. And this is the material which is referred to in the judgment of the courts below. And this is hopefully just to draw the court's attention to the basis for that, those findings. So, page 529. Paragraph 6 of the witness statement of Peter Wright, and that is, at the meeting which was held in relation to this planning application that's subject to this litigation, Andrew Clark described how the community fund for the wind turbine at St Breville's had been used, and then at paragraph 7, Mr. Wright exhibits a document in relation to the St Breville's wind turbine, and you have it on page 531, and that's where you will find, amongst other things, third paragraph up from the bottom, a donation to the St Breville's play group towards purchase of replacement of waterproof clothing for the youngest members of the community. And then, for example, the St Breville's Lunch Club, which last sentence of the penultimate paragraph, the funds will enable the group, including volunteers, to be treated to a meal at a local pub. It's not suggested there's anything wrong with that, good for building community, but it just doesn't relate to the character of the use of the land. So desirable but not material. So that is the respondent's position. But now, if I can, we'll seek to reply to the first appellant's argument that a matter can be material if it furthers the objectives or purpose of planning policy, which is the argument that's advanced. The appellant's argument would extend planning purpose beyond the meaning given to those words in the Great Portland Estates case. It would not relate to the character of the use of the land. It will be anything that furthers the objectives or purposes of planning policy. Mr. Kingston, in his submissions, did rely on one element in Great Portland, and that is in the appellant's case, and he mentioned it, and this is the passage at, so it's tab 22, and it's page 1753. And 671 C to E. I won't read it out because Mr. Kingston's already read it. That deals with the consequences of a land use policy. If you promote a policy which protects a particular use, certain occupiers would be protected. That's a consequence of pursuing a land use policy. That is very different from arguing that anything which furthers the objectives or purpose of a policy is material. And in this case, the community donation is not a consequence of a community-led initiative. In Great Portland, you couldn't protect certain classes without having the consequence of protecting occupiers. The occupiers who use the premises for that use would inevitably be protected. Here, if you have a community scheme, it doesn't inevitably follow that you have a community donation which can be related to purposes not relating to the character of the use of land. And indeed, as I've already referred to, the appellant themselves sought to distinguish between the Community Benefit Society and the community donation. The acceptance of Mr. Kingston's argument would act, in effect, as an encouragement to policymakers to expand the ambit of policy, because if Mr. Kingston was right and anything that furthered the objects of planning policy was material, all you'd have to do is to make a planning policy which encouraged donations to be made to local communities by developers of, the example that I gave was the retail store. That would then further the objective of a planning policy. But what it would do was it would remove the protection identified by Lord Justice Hoffman in Plymouth that materiality is the protection against the buying and selling of planning permission. And the retail store example relied upon by the respondent below is, in my submission, our submission, a valid example, because a policy might be promoted which imposes a requirement on those applying for planning permission for a supermarket to contribute a proportion of turnover to a community benefit fund, and it could be done to encourage local shopping, for example. So the supermarket is told, well, you can't have planning permission unless you contribute 4% of your turnover towards this fund. And as the Court of Appeal observed, it might be 4%, and somebody might say, well, we'll give 5%, or somebody else might offer some other benefit. It might be wholly desirable. It might be used for most commendable purposes, but it would not be a material consideration. And this scheme, however it's described, however much one refers to the Community Benefit Society, what is happening here is that 4% of the turnover is being offered, taken into account by the local authority, and that's where the local authority went wrong. But I also submit that even if the appellant's argument that anything that furthers the objectives or purposes of a planning policy can be material doesn't actually assist them in this case, because there is no planning policy which supports the establishment of a community benefit fund. And I'm going to turn to the National Planning Policy Framework in a moment. Yes, it encourages community involvement in wind projects, but it doesn't expressly support the establishment of a community benefit fund. The reference to a community benefit fund is in the DEC, Department for Energy and Climate Change policy, to which the court's been referred. That is not a planning policy. It is promoted by a different department, and it expressly states, and this is, you've been taken to it, but it's core volume 3, page 977. It states that the 977, this doc on the left-hand side, this document contains guidance on community benefit funds and benefits in kind. And then there's a distinction drawn. These community benefits are separate from the planning process and are not relevant to the decision as to whether the planning application for a wind farm should be approved or not, i.e. they are not material to the planning process. And then there's a reference to the change made by the Localism Act 2011, and that was the introduction of the paragraph in section 70, subsection 2, which refers to local finance considerations. And then in the second column, we have socio-economic and material benefits from onshore wind developments are types of benefit that can be taken into consideration when a planning application is determined by the local planning authority and are not covered by this guidance. So this guidance is making a clear distinction between socio-economic benefits in general and community benefit funds and benefits in kind. So even if Mr. Kingston and his arguments were right, the policy doesn't support the establishment of this type of fund. Mr. Kingston argues that the Court of Appeal, this is the Community Benefit Society point, were wrong to concentrate on the community fund, and if one takes up the appellant's case, at page 85 in Core Volume 1, paragraph 28, my Lord.
I'm sorry, could you repeat the page number?
Page 85, my lady.
Thank you.
Paragraph 28. And the three steps to the argument are these. And I'd extract these from paragraph 28. Land use planning policy encourages community involvement in renewable energy projects. Step 1. Step 2, operation by a community benefit society furthers that purpose. And step 3, the fund is a consequence of community involvement. And those words are taken from halfway down that paragraph. And taking those points, but not in order, I'm going to deal with the third point first, that the fund is a consequence of community involvement. Even if the appellant succeeded in persuading you on steps 1 and 2, it cannot be said that the fund is a consequence of community involvement, because you can have a community benefit society without the fund. And the first appellant itself was very keen to point out the distinction in its summary grounds in the planning court.
Well, you can have the fund without involvement without the fund.
You can, my lady, but you don't need the fund in order to have the involvement. And it's no different from saying that a fund set up by a commercial operator is a consequence of engaging the community. A commercial operator could engage the community and could decide to set up a fund, but it wouldn't make it material. So it falls at step 3, but even if one turns back to step 1, and that is that land use planning policy encourages community involvement in renewable energy projects, one then turns to the policy relied upon, and Mr. Kingston's already taken the court to it. But if the court would like to turn to Core Volume 3 and page 1041, and paragraph 97 of the 2012 version of the National Planning Policy Framework, and bullet points 3 and 4. Bullet point 3 clearly relates to land use because it's identifying suitable areas. And bullet point 4 is support for community-led initiatives outside, including, so it's community-led initiatives in general, but including developments outside such areas being taken forward through neighbourhood planning. But it does not support, doesn't indicate that it's inappropriate, but it doesn't give express support for donations based on turnover. And reference is also made on behalf of the appellant to the planning practice guidance, which one can find at page 1013 in core volume 3. They are encouraged, but again, there is no specific encouragement to donations or funds of the type under consideration in this case. And when one then does turn to the
1013 is in which document?
core volume 3, my lord.
Yes, but it appears in...
It's the planning practice guidance, my lord. So it's a... I'm reminded by Mr. Kingston that it's also in the authorities bundle, and I apologise if it was referred to in the other. But it's the planning practice guidance, which is an online resource, I think it's called, which is changed from time to time, but it's guidance given, planning guidance given by the government.
So this is the same text we looked at before, I think, in tab 33 of the authorities.
I apologise for...
No, it's all right. I just wanted to understand
yes.
what it was. Yeah, okay, thanks.
So it's the planning practice guidance known in the jargon as the PPG.
Yes, thank you.
But the simple point, no specific encouragement to community donation funds in that guidance. It does make reference to the debt guidance, but then when one goes to the debt guidance, you see a distinction drawn, which we've already looked at, between community benefit funds and general socio-economic benefits. And further, in relation to step 1, that this donation fund was material because it advanced planning policy in paragraph 97 of the National Planning Policy Framework and the PPG, there's no evidence that in this particular case the decision maker considered that a community donation fund would advance those policies. So there's no reference to it in the policies and nothing in the committee report, officers' reports, or the minutes to show that it was specifically thought to advance that policy. So it falls on step 3, falls on step 1, and step 2 is operation by a community benefit society furthers that purpose. And the simple answer to this, which is the point taken in our case, is it's not the source of the funds that matters, but their target. So a community benefit society could have a fund for all sorts of different things. But what matters is whether the target is material, whether that is relevant and serves a planning purpose. fact that the source of the funds comes from the turning of the wind turbine does not make it any more material than if the source of a 4% donation from a supermarket came from the opening and shutting of the tills at the supermarket, or more likely contactless payment, but however it was done. So in our submission, the 3 steps to the first appellant's argument set out at paragraph 28 of its case all fall. If I may, I now like to turn very briefly to the Secretary of State's case. We need to go back to core volume 1, beginning at page 129. And paragraph 22. And in our submission, the court should not accept the Secretary of State's invitation to update Newbury to a modern and expanded understanding of planning purposes in the way suggested, because that approach falls into the very trap or the danger which Lord Justice Hoffman identified in the Plymouth case, that if one moves away from an application of materiality, you lose the protection against, using the emotive term, buying and selling a planning permission.
The expansion is in the words policies which bear on the application. Is that correct? Have I understood that correctly? Because policies that bear on the character and circumstances of the development of the land is all right, possibly.
That would be acceptable, and bearing on the application, that would be part of the Newbury test as well, which would be acceptable. But the problem with it are policies. The test of materiality isn't whether there are policies which bear on it. The test of materiality is whether the matter relates to the character of the use of land and whether it relates to the application. And the danger here is if you change it to policies, it could be, if the policies are restricted to those matters, it could be acceptable. But the danger is if you expand it to, why do you need, in effect, to expand it to policies? The touchstone, if I go back to my touchstone, is whether it relates to the character of the use of land and whether it relates to the application.
But what do you mean by it in that sentence?
The matter.
The matter. Well, why can't the matter be a policy?
Well, it could be, so long as the policy was restricted to those matters.
Which bear on the application or the
Yes.
character and circumstances of the development of the land. So what's the problem?
The circumstances, if it's the character of the development, the circumstances could be much broader. And I also asked the question, well, I have already argued, that there's no particular need to change the approach that the courts have taken until now, unless the court thinks that it's important to do so. It didn't cause any issues for the High Court or the Court of Appeal in this case. And as soon as the court starts changing the words, one then asks, well, what are the circumstances of the development of the land? But I don't push that point too hard, so long as it's restricted to the character of the use of the land. And I can't complain about the application, because it has to be relevant to the application. And I'm not complaining about that.
But you might complain about or, which is what I was putting to you.
Well, my lady,
Because you think it's got to be both, don't
it's
you?
got to be both, because it's the first and second Newbury test.
Yeah. So you do complain about or.
Yeah, I apologise. Yes, I do. And I apologise for being slow off the mark on that. But it's got to pass both tests. And the only other observation, no higher than that, I make is on paragraph 29, where there's a suggestion that the Secretary of State says in the second sentence in 29, can see no sound reason for any difference as between the common law test in Newbury, applying to funds outside of Section 106 agreements, and Regulation 122, which is different, applying to what might be essentially the same offering, and that there is sense in having a common law position which mirrors Regulation 122. Well, that's entirely a matter for the Secretary of State. I don't seek to make submissions on that, but if the court were to accept that submission, I would just remind the court that in the Court of Appeal, it was accepted by both appellants that the donation offered here would not meet the Regulation 122 test.
Going to give us a reference?
Yes, I was hoping to, my lord, and I'm just checking my note because paragraph 36 on page 224, my lord. And it's the second sentence. For similar reasons, they accepted that an authority could not require such a donation as a planning obligation, whoever the developer might be.
So that's an elliptical reference to Regulation 122.
As I understand it, my lord. So I'm going to move on to my conclusions, if I may. If this appeal were to be allowed, it would be a departure from the long line of cases which have restricted material considerations for both policy making and decision taking to those relating to the use of land. It would allow considerations which are not relevant to the development and use of land to be taken into account. It would enable local planning authorities to promote planning policies which indicated that in the absence of community donations, planning permission would be refused. And that is the danger identified at paragraph 44 in Aberdeen. And the reference to that is Authorities Bundle, tab 5, page 1285. And the effect would be akin to, or open the door to, introducing what would in effect be a tax based upon the exercise of administrative discretion. That's because a local authority could promote a planning policy saying you don't get planning permission unless you contribute X% of your turnover. That would be contrary to the principles set out in the Vesti case, which is referred to in the respondent's case, and the reference for that is at Authorities Bundle 2, tab 43, page 2147. And therefore, I make final submissions under 3 points. First point is there is no dispute between the parties, appears to be, that the Newbury criteria apply. Second point is, as far as criterion 1 in Newbury is concerned, question of what is a planning purpose, there is no reason to depart from the East Barnet formulation as endorsed in Great Portland Estates. And in this case, it's clear that a donation fund, which can be spent on all manner of things, including the waterproof clothing or lunches in the pub, clearly doesn't relate to the character of the use of land. And it is a leap to say that any measure taken to comply with a planning policy objective is necessarily material, and a leap which we submit the court should not take. And the third point relates to criterion 2 in Newbury, and that is there's a clear distinction to be made between a community benefit, a condition which requires the development to be carried out by the community benefit society, and a fund, which is quite separate, as recognised by the first appellant, and that fund has no connection, particularly as to the target of the money, other than it is offered by the developer. So those are my submissions.
Thank you very much indeed, Mr. Cameron.
Thank you, my lady.
Mr. Simons? Mr. Cameron.
My Lady, my Lords, I propose to address the Court primarily from 3 parts of the documentation. Firstly, going to my written case and working from that. Secondly, to work primarily from the primary authorities bundle, and then also to take an excursion to that part of the core bundle which deals with the framework. So that's my anticipated compass of material. As advertised in the Secretary of State's written case, I want to deal with 3 matters primarily. Firstly, as to the framework and the way in which that picks up on energy policy, but to develop that a little further, to seek to assist with the way in which my learned friend Mr. Cameron has started off the explanation of material considerations in the planning sphere. Secondly, to turn to the question of quite how one addresses planning purpose, either from the authorities or from first principle. And lastly, to turn to this point about the current way in which planning obligations are dealt with under the Town and Country Planning Act, albeit, of course, that this case is not specifically under those regulations. It's because of the interaction, as I draw attention to that. So turning to that first question relating to energy policy and material considerations which arise from planning policy and energy policy. This is, energy policy is a good example of an interaction between the planning regime and other areas of government policy. I use the word interaction because the government has, and has for a long time, had a freestanding energy policy, which applies throughout the United Kingdom. The devolved administrations have taken on land use planning within the sphere of their competencies. But as far as energy policy is concerned, that has always remained a matter for the Westminster Parliament. So there's an interaction which is in fact different, whether one is in England or whether one is in Wales. Here, in respect of energy policy, one sees the same energy policy put into effect, but solely from the point of view of land use planning objectives. So that is the way in which they are intended to interact. So if we could take up, please, the framework, which is best navigated from Core Volume Part 3. So it's Core Volume Part 3 at 10, 14, 15 onwards, where we get to the March 2012 framework. Before we get to those paragraphs which address climate change and energy policy directly, I would like to introduce the Court to the document a little more generally. So turning, if we may, first of all, to paragraph 7, 1021, we see there a main title, Achieving Sustainable Development, a text box which gives what in the planning world is a very well-known definition of that. And at paragraph 7, we see highlighted 3 roles, economic, social and environmental, which are the 3 dimensions of sustainable development. And we're told that these dimensions give rise to the need for the planning system to perform those roles. Just picking up on 1 or 2 words, which we can then perhaps see playing out a little later. So far as the first role is concerned, we have there a competitive economy. So far as the social role is concerned, we see there, towards the end of that paragraph, cultural well-being. And so far as the environmental role is concerned, we see there in the third sentence, third line down, improving biodiversity. Immediately it becomes clear that it's not obvious how a particular application will, in the 4 corners of that application, necessarily engage such wide concepts. So we pick up on how they play out in the framework, the expression of the Secretary of State's planning policy. If we turn forward to 1028, paragraph 28. The framework is a document which supports a prosperous rural economy. So we've touched upon the economic role, and paragraph 28 explains that planning policies should support economic growth. That is not a concept which fits easily within the idea of character of the use of land.
Economic role on 1021 has to do with ensuring that sufficient land of the right type is available in the right places and at the right time to support growth and innovation, and by identifying and coordinating development requirements, including the provision of infrastructure. That's all to do with land use planning.
It's really a matter of overlap. And so there is a broader objective, which is an economic one as to growth. And as my Lord rightly appreciates, it mustn't necessarily be the case, because this is a document concerned with land use planning. It necessarily does both. It also has an impact on the character of the use of land. And it's the expansion from character and use of land to take in other matters, which is the purpose of going to one or two parts of this document, which relate to those sorts of questions. The second example which I would go to...
Isn't the point that it's making that land use planning isn't an end in itself? It serves wider objectives.
Exactly.
But that's what it's about. It's about land use planning in order to meet the objectives that we have in mind.
Exactly. It is about objectives and to sometimes define distinction between an objective and a purpose. Turning to 1032 at paragraph 50, we're there in the context of residential development. Paragraph 50 is concerned with the policy to deliver a wide choice of high-quality homes and widen opportunities for home ownership. And at the second bullet point, that relating to size, type, and tenure. So there, what is being alluded to is the need to address both open market housing and also affordable housing. Again, the same sort of interaction between a social objective and land use planning. A different example of that we see at 1036 at paragraph 72. Simple and short point there relating to education. A self-evident, important objective, and noting the relationship between land use planning and achieving the important objective of ensuring a sufficient choice of school places. When we come to page 1040, we're then in a chapter concerned with meeting the challenge of climate change, flooding and coastal change. And it's to these paragraphs to which a particular attention has been drawn already. It's a composite and fairly compressed chapter. We're concerned with principally the parts which go from 95 through to the end of 97. That is, further to the Secretary of State's written case, that is the expression in the framework of policy in respect of renewable energy applied within the National Planning Policy Framework. Starting off at 95, with support to move to a low-carbon future, and inviting planning authorities when they're preparing their development plans to support that objective, and 3 bullet points explaining how that can be done. Then the same sort of approach, but in the context of making decisions at paragraph 96, referring to the local plans which will hopefully by that stage have been put in place. And then at 97, a more general policy which urges upon all of those engaged in the planning system to help to increase the use and supply of renewable and low carbon energy, and giving 4 bullet points as to what should be done to that end. The fourth has drawn some attention in the context of this matter, which is concerned with the support for community-led initiatives for renewable and low carbon energy, including developments outside such areas being taken forward through neighbourhood planning. I'll say something in due course about community matters and neighbourhood planning. The function of taking the court through those matters is to seek to explain the interaction between energy policy and land use policy as expressed in the framework, but also to identify, as I hope I have, those sorts of instances where there are interactions between objectives and purposes which are broader than simply character and use of land, and that central question of how to plan for and to determine planning applications. That brings me to, subject to anything on which the court would like any further submissions upon, to the precedent planning purpose point, which is from paragraph 11 of the Secretary of State's written case onwards. So that's at page 132 within core volume part 1. And the Court of Appeal identified that phrase as to the planning purposes being associated with the character of the use of land, and did so on the basis of the authorities which were then available to it. And I take no point whatsoever on behalf of the Secretary of State with that being a relevant part of what a planning purpose is. That is why I say this is correct and is what some of the authorities say, but does not go far enough to capture modern planning circumstances, nor the references to planning purposes in other of the leading cases. And so it's that short point which comes out of 28.2 in the Court of Appeal's judgment. And we've touched upon some of the authorities which are relevant to that point already. Mr. Kingston has already taken us to Fawcett properties, and likewise we've had some reference to East Barnet. If we could take up the authorities bundle, starting firstly with Fawcett, I'd like to highlight, if I may, the factual context in which those cases were being decided. So Fawcett at tab 7 within the primary authorities bundle, and as we see from 1308 within the head note, no lettering to help us, I'm afraid, but in the what I think is the third substantive paragraph starting in 1952, we're here concerned with a pair of cottages, and it's being subject to a particular condition relating to it's an agricultural tie case. condition there is limiting occupation to those in agricultural occupation. And so it was in that really quite limited context that the House of Lords is dealing with this whole question, which has found its way through the authorities since then. If we then turn forward to 1355, in the speech there of Lord Jenkins, there is from the middle of the page a paragraph starting, "The law relating to the narrow ultra vires claim is not in dispute and is summarised below." So the second indent there is dealing with the power to impose conditions, though expressed in language apt to confer an absolute discretion on a local planning authority to impose any condition of any kind they may think fit, is, however, conferred as an aid to the performance of the function assigned to them by the Act as the local planning authority thereby constituted in the area in question. Accordingly, the power must be construed as limited to the imposition of conditions with respect to matters relevant or reasonably capable of being regarded as relevant to the implementation of planning policy. So there in that early case, there's already that reference to planning policy as a part of the context. The same point is reinforced going forward to 1358. Towards the top of the page, in fact, starting from the second line, if the council had taken that course, so far as I can see, they would clearly have been acting within their powers. But as stated in the reason, the council's policy was not to permit the erection of dwelling houses unconnected with the use of the adjoining land for agricultural similar purposes. They therefore thought it expedient to impose an express condition designed to implement that policy. And then, two-thirds of the way down through that paragraph, the same point is made. Expected.
Is it clear which policies are being talked about here? Because bottom of 1355,
My Lord, yes.
implementation of planning policy. Am I right in thinking that's just a reference generally to these powers arise under the Planning Acts, which carry forward, in a broad sense, planning policy, and therefore the conditions must relate to the policy inherent in those acts? Because as I understood it from what you described of the facts, there wasn't actually a policy in the background that had been set out by the council. And when one comes on to 1358, the council's policy, that's just what is written into the particular planning permission, as I understand it, in the condition, isn't it? Or the reason given for the condition.
My Lord, it's not a case in which the development plan as such is significantly touched upon within the course of the judgment.
No.
The way I read it is that it's understood to be the common practice and policy that one does not have new dwellings in the open countryside unless it's tied to an agricultural unit requiring it.
I'm sorry, was there a general policy, a local plan policy that said that?
No.
That's
right.
I think this is a case where the development plan was in the process of being prepared.
That's right.
And there was what Lord Cohen calls an outline
Yes.
development plan.
So it's not giving effect to the terms of a development plan. It's policy in the sense of the practice which has become the policy of the decision maker and was in the process of being encapsulated within a development plan for the area.
And can you help? Is that page 1332? Is that the outline development plan?
It is. That is the
being referred
point.
to there.
Yes, it is quite common for the court to have regard to the plans in an emerging development plan, the policies rather in an emerging development plan.
And such would be a material consideration.
Yeah.
And what, sorry, just to help me, what did the outline development plan actually say? Do we know?
It's not expressly set out, so far as I'm aware.
Because bottom of page 1331, Mr. McGarry is saying that the condition was unrelated to the policy declared in the outline plan,
Yeah.
which looks like it is a reference to the outline development plan. I'm just wondering whether we're told anywhere where that policy, what that policy was.
Some assistance, page 1353.
So I'm grateful to Mr. Kingston. The second paragraph from the top relates to the Greenbelt, the metropolitan Greenbelt, and preserving that from the further outward spread of London.
There's also, at the foot of page 1321, the reference to the county development plan, which indicated that the object was to maintain the normal life in agricultural districts, sporadic residential development was to be checked, and houses were not to be made available for city dwellers.
Yeah.
Yes, well, thank you very much.
So it's the sort of thing which has carried through and been quite unremarkable to date as to the constraints on development within the open countryside and in particularly constrained areas such as those around major cities where there are greenbelt policies of constraint. But the reason for going to those references is to illustrate the importance which the court in this case attached to policy in connection with the reasonableness and validity of a condition.
But is there anything in this case that suggests it is a policy other than a policy related to the use of land?
In this case, no, it's not. No.
So how can you expand the word policy taken in its context relating to the use of land into a much wider definition? Or is that something we shall come to in a moment?
It's not something which I can do from Fawcett, and it's not something I can do from East Barnet, because those cases are both very much fixed.
To the use of land?
Yes, very much fixed.
Thank you.
Yes. So, with that in mind, it's worthwhile to have a look at the way in which things developed. At tab 6, going back to the previous tab. So this is East Barnet Urban District Council. We've had several references to this already, particularly from Lord Parker's judgment, and the facts here relate to a different part of the planning regime and relate to primarily to enforcement. And what's at issue is a transport depot for the handling and storage of crated motor vehicles. And as we see from the head note at 1291, that since the use of the parcels of land as a transit depot for the handling and storage of crated motor vehicles was found by the justices not to constitute development, so that's an important staging post, Mr. Cameron has very helpfully already taken us to the provisions in the Act as to what is development. And as the question of change of use was one of fact and degree, the court was unable to interfere with that finding because it could not be said that the justices could not properly have reached that decision. Referring to the 1947 Act, what was considered, what was to be considered was the character of the use of the land, not the particular purpose of the particular occupier. And it's really from this case carried forward that one finds that phrase becoming established. And the purpose of going to those facts is so that the court can see the particular issue that the court was addressing, limited as it was to storage and what is essentially an enforcement case. But if I could take the court to 1298. From the centre of the page has a paragraph starting, "It seems to me that under both acts what is really to be considered is the character of the use of the land, not the particular purpose of the particular occupier." So just pausing there. The distinction which is being drawn there and the contrast is as between character and use of land and purpose of occupier, which is a fairly narrow question and a question which is very much focused upon a modest development and questions of material change of use or not in respect of the storage, which was the factual finding and decision of the court below. What the court then goes on to do, moving across to page 1299, having reviewed the way in which a change of use might come about, and with the of its time no doubt accurate, explaining to us that a dealer in musical instrument 50 years ago had begun to deal in gramophones and phonographs, might have moved on. We can see technological change being taken into account there. After setting out ways in which matters may move on, the court then comes at the end of that quotation to say this question, as I understand it, is one of fact and degree to be answered upon the evidence in the case, and my answer is that the plaintiff's company has not made a material change of use of the land. So that the context there is whether or not that particular change in intensity of a particular piece of land was material or not. And that's what gave rise to the phrase which is somewhat central to the way in which this case is to be decided and debated. That being so, it's then necessary, in my submission, to look at how this then is treated within the later authorities, which are much closer on the fact to what we're dealing with in this case. We can turn up the authority in due course, but if my lords might like to return to the Secretary of State's written case, back in Volume 1, page 135.
Paragraph, please.
So we're at 135. There is a paragraph E. So it is in fact paragraph 14E, my lord.
Thank you.
I there set out paragraph 670, well, from page 670D of Lord Scarman's speech in Westminster Council and Great Portland Estates, which we visited already. And in respect of that paragraph, what I submit is that there's nothing wrong with it at all, but a planning purpose is not limited to the character and use of the land, but rather what has happened via this paragraph is that matters have become somewhat compressed, moving from a case about intensification of use in a storage context to the much broader question which arises on the validity of conditions and the appropriateness of contributions. So, going back to where I started in this, I have no criticism to make at all of what was concluded at paragraph 28 of the Court of Appeal's judgment. I just say it needs to be broader than that. To seek to make that point good in another way, can we turn up, please, Newbury? If we go to Newbury and so back to the primary authorities bundle and turn up in tab 12. The decision of the House of Lords in Newbury, which is somewhat central to the matter to be decided. And turn, first of all, to the speech of Viscount Dilhorn at 1470. There is a section starting the validity of the condition, which is plainly an important section in the context of the case. So 1470 behind tab 12. We have the familiar three tests at the bottom of the page at H, and the words which are to be debated. It follows that the conditions imposed must be for a planning purpose. One sees in the way in which the court addresses these three tests that they are addressed as much in the context of what is said in the Barnett case as in the way in which planning policy is said to be relevant. So if one turns forward to the same point being dealt with by Lord Fraser, 1478, again, we see section 29 set out. And then at F, Lord Fraser goes on to say something about the italicised words and comes, first of all, at G to say, first, it must have a planning purpose. It may have other purposes as well as its planning purpose. But if it is imposed solely for some other purpose or purposes, such as the furtherance of the housing policy of the local authority, it will not be as a valid planning condition. So there, in a negative sense, Lord Fraser is looking at a purpose which at that time and in his view was not a planning purpose. But one can compare and contrast that to the framework which we have, which plainly does consider the housing requirements of a particular area. And so one sees that housing policy for a particular local authority at that time not thought to be something which was relevant to a planning purpose, and so it would be an invalid condition. Not so now, as the then Chapter 6 of the NPPF makes clear. Elsewhere within the judgment, there's a fairly frequent reference, as I've sought to explain in the Secretary of State's statement of its case, that one is having regard to planning policy. So within, and this is the short point which is made within the Secretary of State's written case at page 138.
Paragraph, please.
Page 138, my Lord, paragraph 21.
Thank you.
Paragraph 21, 138. So, in fact, the question about the relevance of policy is in itself, as Lord Scarman accepted, that a planning condition must relate to the provisions of the development plan and planning considerations affecting the land, as must surely and obviously be the case. So the link between planning purpose and policy and the development plan was something which the House of Lords was alive to and expressly referred to within the context of Newbury itself. So in the same way that we've seen reference to policy within the context of Fawcett properties, we see it likewise in the context of Newbury. So either approaching the matter from the point of view of how this phrase, character of use of the land, or looking at it from the point of view of the way in which policy is referred to in these earlier cases. On either basis, the question of what's a material consideration must necessarily include policy. How far does that go?
I want to be clear. Look, 4 years after Newbury, the House of Lords told us what a planning purpose is and what a material consideration is in a judgment, a speech by Lord Scarman with which all the other members of the committee agreed. Are you asking us to depart from that?
My Lord, no, I don't believe that I am.
Right.
The question of what is a planning purpose is one which is on all fours with the expression character and use of the land. That's fairly, in my submission, obvious and clear. The question is whether or not it goes further. And the references to policy are found throughout those cases. And the question then becomes, in my submission, to what extent does that find a proper place within the scope of the Act, which is what Mr. Cameron has very helpfully set out for us already during the course of this afternoon by reference to Section 70. And I just want to deal with the way in which that has been put by the respondents. I don't disagree with anything which Mr. Cameron has said, save that the phrase material considerations, which one finds at the end of Section 70, that any material considerations is necessarily something which is rather fact, or is going to be very much dependent upon the nature of the application which is before the decision maker. So the point was made, well, there's been an express inclusion of particular references to having regard to the Welsh language, for example. But that doesn't really help in understanding that part of Section 70 which relates to any relevant material considerations. And the first and most obvious point is, of course, that there are any number of cases which make very clear that the Secretary of State's planning policy, and each of them, is a material consideration. Much of the work of the planning court is occupied with points of law which arise out of those material considerations, the material consideration which is contained in each of those policies. And so it is, in my submission, much too narrow an approach to Section 70 to say that one is limited to those matters which relate to the character of the use of land. Section 70 is one which, probably worth turning it up. If my lords, my lady, I can turn to tab 4. Tab 4 at 1258. Section 72 sets out and the included references to neighbourhood plans and now the Welsh language. The inclusion of local finance considerations, both of which were referred to. But what Section 72C is concerned with is any other material considerations, which in the Secretary of State's submission is very clearly national policy. National policy must be, and each of those policies must be, a material consideration. And it is for that reason that the Secretary of State has set out in paragraph 22, back in core volume 1, paragraph 22 at 138 over to 139, paragraph 22, a formulation which includes reference to character and circumstances of the development of land, but includes what appear to be 7 contentious words and a contentious or and. So the 7 contentious words are to be found in policies which, and whether that's an and or an or. And Secretary of State's submission on the basis of those materials is that it's appropriate to include those for the reasons which I've given, and that it's an or, because one needs to have regard always to the character and circumstances of the development of the land, which will be predominantly physical questions. But for reasons which I hope I can come to in the morning, unless the court prefers to sit on, it's very easy to find examples which illustrate that, and you can find them just outside the door of this court.
That sounds like a peroration for the day.
Thank you.
Very well. We will adjourn now and look forward to hearing from you further at 10:30 tomorrow morning.